Hi, thank you so much for having me. I'm delighted to be here. Unfortunately, the way my screen system is set up, I only have a small sliver of all the folks who are here, so I can't see everybody, but I will change that when we get to the question part so I can have the gallery view on. But for now, I've just got my PowerPoint here. And I think I've timed it correctly so that I've got just under half an hour of comments and talking points, and then we can open it up for a much broader conversation. But do feel free to jump in if you have a question along the way. And thanks again for having me. I'm excited. So, this is my book. It came out on August 4th. And I always want to start with the story that really just kills me every time I have to tell it. But I think it highlights what my book is about, what a no crime wrongful conviction really is. Rodriguez Crawford was a 19-year-old young man who lived down in Shreveport, Louisiana with his family. He had a 1-year-old son who, by all accounts, he adored, until one morning when he woke up and he found his son lifeless in the bed next to him. And his family members frantically called 911, and it kind of went south from the very beginning. The dispatcher who took the call was very disparaging to the family and of the family as she called the paramedics to go to the scene. People were making unbelievably snide remarks. When the paramedics arrived at Rodriguez Crawford's home, they called it a crime scene. They took the baby into the ambulance and locked the ambulance, waiting for the police to come before they informed the family that the baby, in fact, had died. The police, instead of treating Mr. Crawford as a grieving father, whisked him off to the police precinct where he was interrogated. The medical examiner, without waiting for any kind of forensic results to come back from the lab, declared that the baby had been smothered to death and that it was a homicide. When the lab reports came back proving that there was sepsis and pneumonia in the baby's lungs, the medical examiner dismissed that as incidental. And then Mr. Crawford had the misfortune of being prosecuted by a man named Dale Cox, who is a hanging DA who loves the death penalty and pursued it with quite enthusiasm. And Mr. Crawford wound up on death row for murdering his son. He was eventually exonerated because his son, in fact, had died of pneumonia and sepsis, and no crime had been committed at all. And yet he served many years on death row because of this whole host of factors. He was poor. There was racism in the system. People jumped to conclusions and had tunnel vision and passed along that perspective to all the different actors. A prosecutor who was willing to do virtually anything to get the job done, and a judge who let it happen. So many of you are familiar, of course, with the concept of wrongful convictions. It's been very much focus of the media today. And in most of the stories that you hear, it's of a crime that is actually committed and an innocent person who is wrongfully convicted of a crime committed by someone else. But what if I told you that 1/3 of all known exonerations involve innocent people who are convicted of crimes that just never happened in the first place? And that's what this talk is about. It really is about this subcategory of cases of innocent people convicted of crimes that never happened. So today I want to look briefly at the data about innocence and no crime wrongful convictions. I want to talk a little bit about the factors that cause these no crime convictions to occur in the first place. I want to talk with you a little bit about some ideas I have about what can be done to reduce their prevalence, and then we'll open it up for a conversation. And so let's just start with the big picture. People always want to know how many innocent people in the universe have been wrongly convicted, and the honest answer is we have no idea. Estimates go from anywhere between 1% to 6 or 7%. I like to use 4%, 4.1%. Sam Gross is a leading innocence scholar, and he decided, he ran a fairly sophisticated study, and he determined that if all people who had been sentenced to death remained under a sentence of death, 4.1% of them would be exonerated. And if that's correct, and you consider that there are 2-point-something million people incarcerated in our jails and prisons, and that has been going on fairly consistently for a large number of years, that would be a lot of innocent people. And even if you use a much more conservative estimate, like a 1% estimate, we're still talking about thousands and thousands of innocent people. And of those So we don't know is the honest answer. And we have some new data resources, including the National Registry of Exonerations, which has been tracking exonerations since 1989. And as of yesterday, there were 2,667 known exonerations, and of those, 986 are no crime wrongful convictions, including a case that came out just a week or two ago. Frederick Earl Bain was convicted in Idaho of sexually abusing his 7-year-old daughter. After he had served his sentence and was released on parole onto Idaho's sex offender registry, it eventually was revealed that the girl had made a false accusation at the behest of her mother. They were involved in a terribly bitter divorce and custody battle, and she fabricated an accusation. Eventually, this all came out, and he was exonerated. So just real quick, people often ask me about the data by race. You can see that on this column here, we're looking at all wrongful convictions, and about 36% of people are white, 49% of all exonerations that are known in the National Registry database are Black, and then 310, or about 11%, are Hispanic. The numbers change a little bit in no crime cases. 49% are white, and 39% are Black. So the numbers are a little bit, from a percentage point of view, different, and that's reflective of the difference in cases that occur in no crime convictions. And I've just picked a couple just to illustrate what I mean. Child sex abuse cases tend to pull heavily with white defendants. Drug possessions and sales cases tend to pull heavily with Black defendants. And so some of the data, does vary based on the crime of conviction. And of course, at the end of the day, are there really only 986 no crime wrongful convictions? Of course not. Again, the data is only since 1989. It doesn't include misdemeanors, which is a huge category of cases that involve people who are convicted of crimes that didn't happen. Most people don't even focus on misdemeanors. The data is not there. And there's other limitations within the NRE data. So it doesn't even accurately capture the scope of no crime cases since 1989. But it's a representation. And it's important for us to note that this is just the tip of what I suspect is a much, much larger problem. So then, how do these things happen? It's a crazy concept to think that our state government, right, the state actually spends time investigating, arresting, prosecuting, convicting, and sentencing people for crimes that never happened. We may be able to better sort of get our heads around the tragedy of an innocent person being convicted for a crime committed by someone else, but how do we get to this crazy place where people are being convicted for things that just didn't occur? And part of it is this labeling phenomenon, right? If a crime is if someone mislabels an event as a crime, it triggers the system to do what it does best, which is get convictions, right? If a crime was committed, then someone had to commit the crime. And so people, like the police, will go out trying to find that someone, they'll identify the suspect, and then everyone else works as hard as they can to hold the perpetrator accountable for that crime. In some ways, it's like the tail wagging the dog instead of an objective and open evaluation of the evidence. And in doing the research for the book, I sort of stumbled on what I would call 3 primary triggers, with the caveat that this really is a system-wide problem. But the first is the forensic mislabeling or error of an event as a crime, kind of like what we saw in the case of Rodriguez Crawford. The second is a false accusation that a crime occurred when it did not. And here again, I just told you about the one case in Idaho where a false accusation was made in the context of a bitter divorce. And then thirdly, the police, either because they're engaged in outright, flagrant, jaw-dropping, horrific misconduct where they manufacture crimes that didn't occur, or because they're engaging in overly aggressive and biased policing practices that result in the over-policing and arrest of poor people and people of color for crimes that simply didn't occur. And so let's take a look through these concepts, and we can sort of take it from there. So I always feel compelled to talk about Cameron Todd Willingham because he was actually executed for the arson murder of his 3 children that fire experts have gone back and they've examined the science, and they've said this was no arson. This was an accidental fire. And he, of course, is not the only person who has ever been wrongly convicted for arson. There were 3 men who were convicted of a terrible fire in Brooklyn in 1980 that killed a young woman and her 5 children. And one man died in prison. The other 2 served 33 years. One went blind while he was serving his time in prison because of glaucoma. And again, a fire expert went back, John Lentini, and he recently, sort of was able to establish that that fire was based on an electrical malfunction and was certainly not arson. So truly tragic events have occurred when there is forensic error, such as what I just described. Other examples, a suicide is mislabeled a homicide, or a living person emerges from the dead. One of the first known no-crime wrongful conviction cases actually is of these 2 brothers, the Bourne brothers, and they were charged with the murder of their missing brother-in-law. And literally, as one of the brothers was being sort of prepared to go to the gallows, the brother-in-law turned up alive and well in my home state of New Jersey. So that has occurred. You may have also read about cases where, for instance, an infant dies and the caregiver who was tending to the infant is charged with murder based on the shaken baby syndrome theory. There's also crazy cases, like perhaps you're familiar with the Choctaw 3, where 3 developmentally disabled African-American people were charged with and wound up pleading guilty to, wait for this, the murder of an infant that not only was never born, but was never conceived. Swear to you. And a lot of this goes back to this idea of tunnel vision, of focusing in on a theory from the start and then doing whatever you can to make their case, to make the case happen, to get that conviction. So if mislabeling sort of is one category of wrongful convictions, triggers for these no crime wrongful convictions, the second is the police and actual misconduct, outright lies and misconduct that cause no crime wrongful convictions. And here I'll tell you a little bit about the Baltimore Gun Trace Task Force, but many of you live in cities where you can probably, you're nodding your head and saying, I've seen this in my own jurisdiction. The Baltimore Gun Trace Task Force, the name as it sounds, they were formed to try to get guns off the street, but in reality, they engaged in some of the most egregious conduct you can imagine. They engaged in baseless searches. They robbed people. They carried toy guns on them to plant in the event that there was a shooting. They clocked overtime when they weren't working. They stole drugs and sold them on the street. And in one instance, there was a man named Umar Burley who was in a car, and he was sitting in his car with his cousin, and these masked men pulled up next to him with their guns drawn. The masked men, by the way, were members of the Police Gun Trace Task Force. Umar Burley, of course, had no idea, sped off to get away from these armed gunmen and crashed into a civilian and killed him. And in an effort to cover up their own wrongdoing, the Gun Trace Task Force planted an enormous amount of heroin in Burley's truck. And Burley, who had a criminal record, would have been facing a life sentence, well, the equivalent of life sentence, 30 plus years, had he gone to trial and tried to make sure that his word was credited over the word of these police officers. And so he pled guilty. And it wasn't until the Gun Trace Task Force corruption was exposed by the feds that the case of Burley was revealed to be part of their misconduct. And he was completely exonerated of any wrongdoing. But in the 15 years that he served in prison, his girlfriend died, his grandmother or his mother passed away, and many of his community ties were destroyed. And in Chicago, there was this huge shakedown scheme where officers would go into the poorest of communities who had no money to burn at all and demand payouts. And if the people didn't give them these bribe monies, these protection monies, they would plant drugs on them as well. So this isn't just unique to Baltimore. It's not unique to Chicago. There's incidents in Philadelphia. This has happened. There's been incidents in Los Angeles. So this is unfortunately something that occurs where the police create crimes that never happen. But there's also aggressive policing policies, and those policies are set at a higher level. And they tend to target poor communities, and particularly communities of color. And for instance, what happened in New York City. So there was this New York City trespass affidavit program. I actually, when I was practicing in the Bronx as a public defender, I saw this firsthand. People would routinely be stopped and arrested in the lobby of their own building, which, to be clear, is clearly not trespassing, or visiting their aunt, that is also not trespassing, and they would be arrested. Between 2006 and 2010, almost 95% of people who were stopped were Black and brown. And people would get arrested and they would be booked, they would be fingerprinted, and sometimes they'd have to spend overnight in a jail cell waiting for their arraignment the following morning, depending on what time they got picked up. And they would invariably plead guilty, not because they were guilty at all, but because they didn't have the capacity to keep coming back to court to fight a misdemeanor charge. And so that happened far too frequently. And it was the products of this broken windows policing philosophy. And again, you see this all the time in places like, going back into Baltimore, where there was a big loitering push. They were arresting particularly young Black men for loitering when they were not in fact doing anything of the sort. And people would routinely plead guilty. Those are convictions that are for crimes that just didn't occur. And again, you can see there's a story that I talk about in the book about misdemeanors. There's a guy, Wassily Gregory. This is just such a fascinating story, and no one would ever have known about this. So Wassily Gregory's walking down the street in Alaska. This guy's backpack on, it's in the evening, and a police officer jumps on his back, beats him up. Kind of like, just stunningly, this occurs. And then the police officer arrests Wassily Gregory for resisting arrest and somewhat maybe disorderly conduct, and takes him off to jail. Wassily pleads guilty and goes home. And that really should have been the end of it, in the sense that nobody would have known about it, except there was this anthropologist who happened to be in this particular area of Alaska who happened to see the whole thing go down. And she was so outraged that she marched over to the precinct and filed a complaint. And because she was so adamant that something terrible had gone wrong, the investigative folks at the police department there looked into it. And there was a video recording from a street security camera that had captured the entire incident on film. And between the eyewitness testimony and the video, this event was revealed, and Wassily Gregory's misdemeanor conviction for resisting arrest was overturned. And I saw myself, I would see clients come to arraignment, all beaten up and bruised, charged with resisting arrest and often something else like a disorderly conduct. And I'd say, what happened? And they'd say, I don't know, the officer said I wasn't respectful enough to him. And yet there would be this very, misdemeanor charge of resisting arrest. And you can see there's marijuana, there's loitering, there's all kinds of misdemeanors that don't get enough attention. I like to say misdemeanors really matter because they create a criminal justice footprint that follows people for the rest of their lives. So if those are some of the ways that these things get started, it's important to note that there are actors all along the way that could intervene, but that don't, and in fact make it worse. So prosecutors are supposed to be these ministers of justice, right? We've heard that many times before. But instead, they contribute to these problems. They rubber stamp police arrest. When the police arrest somebody based on probable cause, all they need to say is it's more likely than not that a crime was committed and that this person committed that crime. But the prosecutors are supposed to vet that assertion. And they often don't. They just rubber stamp whatever the police say happened. And then when they look at their case later on and they realize there's weak evidence, or perhaps there was misconduct engaged in by the police, they'll just offer a great plea deal to entice a defendant to plead guilty instead of doing the right thing, doing justice, which would be to dismiss the case. And the problem with making plea offers, we know 95% of all cases are resolved by pleas, is it insulates the entire process from review. We never get to that police misconduct. We never get a chance to see what that search was based on or what kinds of actions the police took. And frankly, it insulates the prosecutor themselves from having to do the work of admitting that they were following along with the case that didn't have an evidentiary basis. And once they get in, once they say we're going forward, then they engage in all kinds of machinations to make sure their convictions will be possible, including, as I'm sure we all know here, Brady violations. They are required to turn over exculpatory evidence by the Constitution. The Constitution mandates that. And yet, we know time and again that they don't do that. And they will often result in an innocent person being marched off to prison. The other thing that prosecutors do is they will use unreliable forensic evidence, evidence that doesn't pass muster at all. They'll put expert witnesses on the stand who are anything but expert, or they'll put unreliable witnesses on the stand like jailhouse informants with every incentive to lie. And they'll know that, and they put that on because that's what they need to do to build their case. And then the final part, although there's other contributing factors for sure, is even when they're presented with unbelievably strong and compelling evidence that they have made a mistake, they will refuse to admit error. And here, there's a case of Gerald Davis. He and his father were convicted of rape, and they were exonerated conclusively by DNA evidence. But rather than saying, okay, I'm sorry, we made a mistake, the DA went back and retried Gerald Davis under the theory that he raped the woman but didn't ejaculate. The jury saw right through that. He was acquitted, and yet he had to endure the pain of another trial on top of the 8 years that he and his father both served in prison for a rape that ultimately, it turns out, was fabricated and did not happen at all. So these are just some examples of the way that this works. There was a man named Charles Robbins who served 26 years on Nevada's death row for murdering his daughter. And again, once, and I'll tell you a little bit more about that when we get to defense lawyers, but once he was exonerated conclusively, or once there was really strong evidence of innocence, the prosecutor insisted on him pleading guilty or threatened to take him to trial again. And he took the plea because he didn't want to have to face another trial, and he wanted to get out from this horrible situation that he had been in for so many years. But one of the reasons prosecutors are able to do all of this is because they have absolute immunity from prosecution. They can't be held liable for the things that they do in the context of their official duties as a prosecutor. And that seems to be something that we need to be thinking about carefully as we continue to think about criminal justice reform. So prosecutors get to do all these things, but judges, if you look at the wrongful conviction literature, judges get a pass. I don't know why they get a pass. I don't think it's deserved. There are a couple different ways that judges fall down on the job. They, in many jurisdictions, are elected, and they succumb to elected pressures. So instead of being neutral and objective arbitrators in the courtroom, they are playing to a second audience, the electorate. And there you can see, I have a little slide here of an ad that was successful in helping an incumbent Democratic Supreme Court justice in Wisconsin get unseated because the accusation was that this judge was not tough enough on crime. Judges themselves are people. They have their own biases and bigotry. There has been overt, explicit bigotry recorded in courtrooms. There has been much more subtle prejudice and bias in courtrooms, but judges, are part of that culture. Some judges were former prosecutors, and they haven't quite shaken off their role as a zealous advocate for the state who's seeking a conviction, and embrace their new role of this neutral observer in the courtroom. And so they will also approach a case in a way that's biased and unfair to defendants. But in addition to that, those sort of internal things, they also don't do their jobs particularly well. So they might fail to exclude unreliable evidence. And here is a picture of bite mark evidence, right? Forensic odontologists have been running around the country for decades saying that they can match a person's bite mark on the skin to somebody's teeth. You can't do it. And it has been officially debunked. The National Forensic Science Academy has said, that is garbage. And yet judges allow that and other kinds of junk forensic science into their courtrooms. They don't do their jobs of excluding unreliable evidence, whether it's in the form of forensic experts or just unreliable jailhouse informants. They need to do a better job of that, right? They'll ignore bad lawyering, they'll ignore sleeping lawyers or intoxicated lawyers. They'll ignore prosecutorial misconduct, or they'll look the other way. These are all factors that judges, if they intervened better and did their jobs better, would make a big difference. They take pleas without ensuring there's a proper factual predicate. And then finally, they're part of the whole plea culture. They give tremendously long sentences after trial when a defendant dares to assert their constitutional rights to have the prosecution prove their case. You know, here I always think of the Tulia, Texas cases. You may be familiar with them. There was a white officer named Tom Coleman who had been brought in on special assignment. He goes into Tulia, Texas, single-handedly winds up arresting like 10% of the Black population for drug charges based on his say. So there are no labs corroborating his story. There are no witnesses, no wiretaps, no nothing. It's just Tom Coleman's word. And the first few defendants went to trial and lost. And the sentences imposed were shocking. And so the rest of the defendants, seeing the writing on the wall, quickly pled guilty. And judges sat through that and did nothing. So I do think it's important to take a second and talk about judges, because judges are so often not talked about. Defense lawyers, here we go, we're all sitting here. You know, a lot of lawyers understand that public defenders were understaffed, were underfunded, caseloads are too high. And in some jurisdictions, there is a culture of leave and unpleadum. I talk about in my book how, I think it was in Louisiana, they did a study and it was 7 minutes from the time an attorney met the client till the time of entering the plea. I mean, I don't know about you, but I can barely get through what's your name in 7 minutes. And so that's a huge problem, because people are just sort of processed through the system really quickly, and that's how no crime convictions occur, particularly at the lower levels, at the misdemeanor levels. There's institutional pressures, right? You have to play along to get along. If you're a repeat player in a courtroom, you may not want to make the judge too angry at you about one case, because it might harm another client down the road. Of course, that's not what you're supposed to do, but that might happen. We all are familiar with stories of unmotivated or undertrained or unprepared or intoxicated lawyers. You know, the story I was telling you about the guy, Charles Robbins, who was on Nevada's death row. His lawyer, with a simple test up front, could have established that the baby had died of scurvy, believe it or not, and never did the test, never examined the x-rays, just took the prosecutor's word that there had been abuse until death. And it wasn't until a new set of lawyers came on the case that they tracked down an expert and then hired a prosecutor's expert, and everyone agreed it was scurvy. But that could have been resolved at trial had the defense lawyer done even the most minor amount of investigative work. And part of the problem is there's very little funding for investigators and very little funding for experts, and that becomes a big issue, particularly in cases that rely on forensic expertise. And then finally, defense lawyers can be the most dedicated, the most aggressive, the most zealous, but you can't attack what you don't know. And if evidence is being hidden by the prosecution or the police, there's no real way a defense lawyer can do much about what they don't know. And so that's a huge issue that comes up. I'm not sure how I'm doing on time, but these are just some of my suggestions about ways that we can start to think about improving no crime wrongful, or reducing the prevalence of no crime wrongful convictions. And you'll see that a lot of these not only would improve no crime wrongful convictions, but would help improve the criminal justice system at large. So I'll walk through this really quickly because I think I'm getting close to my half an hour. The first would be in the area of forensic science. We really need to make sure that forensic labs are independent, that forensic labs and forensic scientists are certified. You know, when you think about the forensic misconduct that also causes no crime wrongful convictions, the Annie Dukins of the world who are just manufacturing lab results willy-nilly, regardless of whether someone in fact had drugs on them or not, that can only happen because of a lack of supervision. So we really need to take a look at how we're doing forensic science we were moving in that direction, and then sessions came in. When we're talking about medical personnel, particularly medical personnel who are in a position to make a diagnosis that's a crime diagnosis, it's really recommended that we create devil's advocacy panels where other doctors can come in and say, what are some other reasons that this, for instance, child could have died other than your suspicion of a homicide? That's been shown to make a difference. Open file discovery might reduce the prevalence of Brady alone. Again, there are some problems with that or questions about that. Taking a look at absolute immunity standards would allow us to perhaps start to hold prosecutors accountable, increasing funding for defenders, increasing access to experts, training about cognitive biases, including tunnel vision. All of that could make a huge difference. Bail reform would make a big difference, particularly at the lower end for people who are willing to come back and fight their day in court. They often will take a plea because they don't want to sit in jail waiting for their day to get in front of the judge. And so with bail reform, that can make a very big difference. And then finally, and I know I'm going through these quite quickly, we could see changes in policy that would reduce what we criminalize in the first place, and that would reduce the exposure of people, particularly poor people and particularly people of color, and reduce their criminal justice programs. And that is where I will end. I think we're a little bit after 1:30, and I do want to make sure we have time for questions. This is my contact information, that's my website. And Andrew, are we good? Should we stop the share and take some questions?
Yeah, I can jump in actually. Andy has asked me to sort of take the reins a little bit on the Q&A portion because Andy was having some trouble with his microphone. So yeah, so I think, thank you very much for that. That was excellent. And I think there are probably a lot of people who might have questions. So if you do have questions, you can either click that little raise hand button or you can just unmute yourself and start asking, and we'll start the discussion going. But we'll open the floor now if anybody wants to jump in. And I can get us started with one, just a little bit of a teaser for the group. I would be curious, what role you would see for researchers in the indigent defense space to sort of help with those steps forward that you were talking about, the kinds of research questions we might ask to bolster some of your findings in the book and some of your arguments in the book, that the research community can be asking those questions in order to help with those steps forward.
Yeah, I mean, well, there's a whole bunch. I think in the area of forensic, there's just so much research that needs to continue to be done to push forward the agenda that has been set out by the PCAST report and by I think most folks here know about the two major reports in the forensic science areas that really called for reform. But again, there was this movement to have that established, and then Jeff Sessions came in and ended it. And so we still need to kind of take a look at what's happening in the forensic space, whether these recommendations have been followed at all about what's junk science, where comparative forensic matching is still being allowed in courts, and what we can do about it. I'm also fascinated by the lack of research over how judges, there's some, but I'd love to see more about what judges do in evaluating the admissibility of forensic evidence. And so, for instance, we know that they're not, judges are lawyers. They don't have a particular expertise. And so one idea that I've been wishing somebody would pilot is what would happen if there was an objective sort of forensic scientist who was made available to judges to consult with whenever there was a complex forensic issue. Would that help with the way that they were treating forensic evidence on the ground? And then I think, part of a national conversation that's happening now in the area of immunity, right, where we've been talking a lot, and it's fascinating. I teach undergraduate students, and I mentioned something in class just yesterday about qualified immunity, and I saw everybody shaking their heads. That's not something that would have happened even a year ago. But what people don't know, so people are starting to get familiar with this concept of qualified immunity for police officers, but very few people are aware that prosecutors have absolute immunity. And I would love to see some research, better research about what that would mean and what it would mean to shift to a different model of immunity or some kind of legal standard for prosecutors. So that's two areas. And then I think I was just clicking through real quickly now that I'm back off my screen share, and I saw Jenny Roberts was here. And I know she's done some wonderful work around misdemeanors, but I also, there's so many issues. Hi, Jenny. There's so many issues around misdemeanor convictions, particularly for no crime cases, that we just don't know that much about. I document in my book some, but it's still more anecdotal than I would like to see it. And so that's another area that I think is really ripe for research, and it's so important because it affects millions of people.
Yeah, Jenny, you had put your hand up to contribute to this discussion. So
Oh,
yeah,
I just
please.
wanted to say hi to Jessica. No, I do have a question. Hi, Jessica. It's so good to see you. Thank you so much.
Great to see you too.
I actually, you just sort of previewed or asked a question, which is, how do we think about this in the misdemeanor context? Because, you're referencing, I did write one, I try not to write about innocence ever, actually, but I had to once because it just happened. But I was, going through at that time, I forget how many, 88 or less than 100 cases on the National Registry of Exonerations that involve misdemeanors. Most of them are no crime cases, and so that's pretty notable. And I think that's an important difference, actually, between most, I did not realize the numbers in the felony realm, but still, I think overall there are far higher no crime exonerations in misdemeanors. And of course, when you were telling the trespassing story, we were public defenders at the same time, and so that totally resonated with me as a prime example from practice, but one of many. And on the registry, there's a lot of things like, there's one, I think, thing, and this is the research question: how do you show that there's more of this going on? So one of the cases on the registry, at least, was a disorderly conduct or a police, or a failure to obey, one of those got the cop mad kind of cases where body cam actually exposed that was not the case at all. We have tons of body cam. Defense lawyers get it all the time in cases. How do researchers use that? I tried to put together some kind of project looking at body cam. I was just talking to a reporter the other day, and he was like, "Oh, that's so interesting. How would I do this?" I was like, "I don't know. How would you do it?" And so I feel like with misdemeanors, it's overwhelming because there's so little that's actually collected, at the state and local level, and there's so much information now with body cam. It's almost, like there's this tension between those two. And I just wonder what thoughts you have on, how might we delve into that more deeply?
Into the issue of body cams?
Into just any, that was just an example, like body cams to show no crime, disorderly conduct's failure to obey is one example of a no crime misdemeanor that I think we would see a lot of if we could get on top of the, tip of the iceberg or whatever, however you want to characterize it. I just wonder if you had any other thoughts of other types of cases or other ways into kind of exposing that.
Yeah, I mean, the problem, of course, is nothing gets exposed if people are pleading out early, at an arraignment time, because then nothing's ever investigated. And we have some structural problems in the context of misdemeanors that maybe don't exist in the context of felonies, because people stick around for felonies longer than they do for misdemeanors. Another example, and I talk about this in the book, is resisting arrest. Police officers will also engage in really violent behavior up front, and then to cover it up, will arrest somebody for resisting arrest and maybe tack on some underlying harassment or disorderly conduct kind of a thing. And it's only when there is some kind of recording that we ever find out about it, because it's just not, it's very opaque, and it winds up being a credibility contest. And unfortunately, still, most of the time when it's an officer's word versus the word of somebody, particularly somebody who maybe has a prior misdemeanor conviction, the officer's almost always credited. So it's a huge problem in terms of how do we get underneath these cases. They're so often not even explored, or discovery is not even adequately ever obtained. So I don't know. I don't have a great answer, but it's really troubling. And people are always like, "Oh, it's just a misdemeanor." It's not just a misdemeanor. I mean, this, misdemeanors have very serious lifelong consequences. So.
All right. I will remind folks who put up hands during the actual presentation, you can put them up again now to ask your questions, but I want to read one out that came in through the chat to me that I'm curious about myself. I'm curious what you may make of the most common charges in non-crime exonerations. I'm struck by the contrast between the believe victims narrative, common in our public discourse these days, and what we can learn from exonerations, and especially from no crime exonerations, about investigations and prosecutions of sex crimes specifically. And that question came in from Annabelle Frazier. And I'm also very curious about the answer to this
Yeah,
one.
so it's so interesting because when I was writing the book about false accusations, I really struggled because one of the major issues in sexual assault cases in general is that victims are not believed, right? Survivors are discredited by the police and they're not taken seriously. And in fact, in the book, I document a number of cases where young people came forward and said they were raped, and the police not only didn't believe them, but charged them with filing a false report, if you can believe. And it wasn't until the person went out and raped again and was eventually convicted that they went back to these women and said, oh yeah, I guess you didn't file a false report. So I really struggled with that. But the truth is that when you talk to law enforcement personnel, they're really confident about their ability to detect truth from lies. And research has found they're about as good as a coin toss, about 50-50. They're not much better than lay people. And so, when false accusations are made and the police credit them, that also creates a huge turbulent problem, right? And so there are flags, I think, that the police should be trained at least to consider when evaluating whether or not a crime was committed. And some of it, had anyone in the case where the Idaho case that I just showed you where the man was exonerated just a couple of weeks ago, I mean, no one had done the research to show that the mother had very significant history of all kinds of things, and that the mother had been the one who first met with the daughter to create the report that then got shared out. There were lots of problems with the way that the girl came forward to report this incident, and nobody really looked at it twice, and the police just went forward. There are things like that where people should, the police could consider better sort of what the context is. Brian Banks is another interesting example. They just made a documentary movie about him. If you guys are looking for movies to watch, and he was this very promising high school football player. And he was so promising. He had already been given a full scholarship, and the NFL was looking at him, and he was really on his way. And he was accused of raping a fellow high school student who, it turns out later, fabricated the entire thing for reasons, she wanted to get herself out of some other trouble. And the reason she never recanted was because she sued the district, and her family made a tremendous amount of money. And she didn't want to have to return the money, so she never came forward. But that whole context could have been evaluated differently had anyone kind of thought critically up front. And so, Abigail, I do think it's a struggle. You don't want to disbelieve people who have been victims of crimes. And yet you do want to take care to carefully think through when people come forward and why, because wrongful convictions do occur based on false accusations.
Yeah, it's a challenging question, certainly. Well, I saw that Thea Johnson has raised a hand, so if you want to unmute and ask.
Hi, sure. A baby just started crying as I start talking. I came in a little late, so I may have missed this, but I would just be interested to hear. A lot of this feels like a real issue with plea bargaining. And you went through it. No, lack of a factual basis, the trial penalty. I was wondering what sorts of cases ended up going to trial and then getting convictions. So no crime cases that actually there was in theory, a full airing of the facts, which were not real facts. I mean, is there a difference between the kinds of cases that you saw in your research went to trial versus the ones that went through plea bargaining and then we just don't hear the whole story, and so it's much easier to have a no crime conviction, because it's such a crazy thing to think of cases going to trial, no crime cases going to trial, and then resulting in convictions.
Right. I don't know that I can sort of say that with, I'd be making it up, frankly, if I answered, well, it was all of these kinds of categories. But clearly there are cases, but I don't think it's unique. Like if you're being charged with a homicide in a capital case, you're almost always going to go, take that case to trial unless someone's making you an offer you just can't refuse. And a lot of the cases that I looked at in the book do involve either capital cases or homicides, or very serious, sort of sexual assault kinds of cases. But I don't know that I could extrapolate and say, more of those cases in the no crime context go to trial versus very serious actual guilt cases in the capital context or in homicides or rape. I think a lot of it depends on what plea offers are being put on the table. So I don't know, but it's a great question. It is a great. I don't know. I could, you could probably play around with the data in the National Registry, and actually their data about trials might be a little bit better than in the context of pleas, because oftentimes pleas aren't overturned, and so the National Registry of Exonerations obviously only includes exonerations, and most plea bargains do not result in an exoneration. So it's an interesting question. I don't know how we get at that data, but it's something to think about for sure.
Thank you. It's such an interesting, topic. I can't wait to read the book.
Oh, thank you. And actually, it's funny, I teach a class on wrongful convictions to undergraduates, and I stumbled on the 1/3 number a couple years ago, and I was like, wait, I need to know more. And that's how I started writing about it. I couldn't believe it. I really, for someone who knows what I know, I still couldn't believe the scope of it. So yeah, I think it is really, it's interesting, at least to me.
I know personally, I've been struck by the data that comes out of the exoneration database. For instance, there's data that shows that a lot of the exonerations that have occurred, people were exonerated for different reasons, DNA evidence, whatever, recantations, whatever it might be, but there was bad forensic science in all of those cases too. So It's not necessarily that the forensic science was the reason that they were exonerated, but it is the reason they were convicted wrongfully. And that is just true in so many cases. And it's interesting to find these huge numbers, around crimes that didn't occur and forensic science problems that aren't even the reason the case gets overturned some of the time.
So down in Harris County, Texas, I don't know if there are other questions, but real quick, down in Harris County, Texas, the police were routinely stopping Black and brown people, and they would do field tests, which are just on the side of the road kind of tests to establish whether or not drugs are present. And based on a positive, they would arrest people, and then they would be hauled into court, and prosecutors would say, okay, here's a quick plea, take it or leave it. If not, we're going. And people would plead guilty. But Harris County did something really weird, which is after the plea convictions were secured very early, they still sent those field tests to the lab for confirmation. Most places don't. Once a plea is entered, it's over. But they waited to get when they got the results back, they actually sent these out. Literally hundreds of people had pled guilty to having controlled substances that the labs were like, nope, no drugs. And Harris County did another extraordinary thing. They went back and tried to find as many people as they could, which represents a lot of those drug cases in the National Registry database.
Right. That's the most extraordinary part, is the county proactively going back and saying, oops, we goofed, we want to, because that just doesn't really happen either. Even, going back to my days of working with some folks at our state public defender's office in Ohio on the hair evidence kind of analysis was really a struggle to get people even to pay attention to it and to go through old cases. So there is another question actually that came in. Do you have any thoughts about improving the quality of things like judicial assessments of credibility during the preliminary phase on motions hearings? Any thoughts on how we could actually improve their ability to make these assessments?
Something goes terribly wrong, because I feel like when you talk to people, yes, Jenny, you're ahead. Sorry, just got Jenny's comment in the chat that let's not give the prosecutor too much credit. That is true.
Fair enough.
It's fair that they went back and really did try to find all these different people. They didn't find everybody, but I do give them props for it. But you're right, a journalist did kind of blow that wide open. But in terms of judges and their credibility assessments, to start, and this is such a modest to start, I'd actually like to see them do it with a true and open mind. I mean, so many times it's just a pro forma kind of oh yeah, okay, you're good. They don't actually consider why people are testifying, what the incentives are. You know, when you have somebody hauled in their orange jumpsuit saying, oh yeah, I'm here out of the goodness of my heart. I mean, we all know that's not true. And the prosecutor saying, well, I didn't promise them anything. We all know that's not true. Or at least not technically, you know, maybe they didn't technically promise something, but we know there was some kind of benefit looming in the background. Judges know that too. And I wish there was a way to prompt them to actually do their jobs, which would be to do that credibility assessment, to make the prosecutor say on the record, you've had no conversations and no benefit has ever been even floated as a concept at all. No, you know, you haven't talked to the police about informing. Like, I just don't believe that judges are doing their jobs well in that arena. That doesn't get us all the way there, but it would help if they would actually hold the prosecutor to the standards they're supposed to. And if they would do their job in vetting evidence more.
I know a solution that's often used in that kind of context is to create a need for on-the-record judicial fact-finding, for instance, to support different kinds of conclusions that they're making. So I'd be interested in something that says, you know, a statute, let's say, in some state that tries out, when you make a finding of credibility, these are the things you have to say on the record are true, and at least make the judge have to, you know, and maybe the prosecutors too, have to think through, can they truthfully say those things into the record?
Right, and then the great thing about doing that, spoken as a former appellate lawyer, Steve, and as I am as well, you know, I mean, is then there'd be a record. So if we later found out that, oh yeah, Bob Smith, who came in saying he was doing this because he just had a twinge of conscience, we could say, oh, actually 5 years ago he got out, you know, from the life sentence and now he's walking the streets again based on this deal that didn't exist. It would be wonderful if we had that kind of record. So yeah, I agree with you.
Any other questions about this really fascinating and complex issue? I know that at least one person put up a hand while the sort of presentation was going on. So if that was you and you still have a question, please do indicate that now. We have about 7 minutes to ask other questions. I am definitely interested in this situation that seems to occur sometimes, that journalists dig into stuff and then sort of shame. This is also what happened with the hair cases, sort of shame people into paying attention to issues that they otherwise wouldn't have paid attention to. And I think there's a role for researchers to do similar work around that, right? To publish research papers based off of these statistical findings, whatever it might be.
Yeah, and I mean, in the case of both Cameron Todd Willingham and in Rodriguez Crawford's case, journalists really played a pivotal role in exposing just how flawed their convictions were. And without them, you know, that never would have happened. And Maurice Posley, who now works over at the National Registry of Exonerations, he used to work for the Chicago Tribune, and they did all sorts of wonderful reporting around this. And, you know, I think it was Jenny who said this earlier, and she doesn't like to talk about innocence as much, you know, and I don't know exactly, I don't want to speak for you, Jenny, but, you know, I understand that because so much of our criminal justice system is about, you know, people who in fact did something and how do we treat them and how does the system work? But one of the reasons I like to talk about innocence is because it gives us an even playing field. Nobody, even the most diehard conservative, you know, law and order kind of person, nobody wants to see an innocent person who's wrongly convicted of a crime that never happened. Nobody wants to see them go to prison. And so if we can bring everybody to the table and everyone can say that's bad, and we look at the factors that lead to these types of convictions, a lot of it, frankly, spills over into the rest of our criminal justice system and can ultimately improve the system as a whole. You know, I often say, we have a system that has beyond a reasonable doubt as our standard of proof, right? The prosecution has to prove a case beyond a reasonable doubt, but that is not beyond all doubt. That is not to 100% certainty. And yet we have a system that is also so bad at allowing people to prove error, right? So once you're convicted, the whole system works really efficiently to get you convicted, and it's so difficult to prove that there was error, and yet the standard by which someone gets convicted has error built into it, right? It allows for that possibility. And so again, I think for me anyway, talking about no crime wrongful convictions just gives a really powerful platform, provides a powerful platform to have a much broader conversation about why we need to better fund defenders, why we need to stop bringing so many people into the system in the first place, why we need to hold prosecutors accountable, why the police need to sort of, again, be held accountable for what they do on the streets and in their policies. So yeah.
Well, thank you very much. I'm not seeing a lot of hands raising, and we're also near the end of our time here. So if people want to add some final thoughts, we can do that, but we're going to wrap up within the next minute or so.
And I'm seeing somebody was just telling about their experience. Jennifer was talking about her experiences representing somebody in a shaken baby case.
Yeah.
And those cases are terrible. And you know, we're starting to, there have been some changes in legal standards, right? You're not supposed to ever have someone be convicted just based on the say-so of an expert who says they're shaken baby. There should be more other than the triad of symptoms. But yeah, it's really, those cases are horrible. Maybe it's because I'm a parent, but every time I read about cases where parents are sort of whisked off and convicted of murdering their own child instead of being allowed to grieve, I just can't imagine the pain that comes from those types of convictions. And particularly when there's no evidentiary basis for it, it's a terrible tragedy. So yeah, Jennifer, it's awful.
Well, that's we really appreciate you taking the time to talk about this really important issue. The book is out now, Smoke But No Fire. Check it out. I think I saw some people saying they're excited to read more and learn more from your book and engage with this issue.
Yeah.
Thank you again. Yeah.
This is my contact information if anybody does want to get in touch. My email is henryj@montclair.edu. I teach at Montclair State University in New Jersey. And you can check out my website where there's also contact information there.
And I also wanted to make sure to say that we recorded this and we'll be posting, this just went in the chat. Thanks everybody for participating. We'll post the video in the coming days on our Vimeo channel. The link is in the chat and we'll make sure that we we post that to Twitter so that people can see more of that. I also wanted to thank the Deason Criminal Justice Reform Center for hosting our monthly chats on their Zoom account and providing some much needed support for getting these things working and registering participants. So thank you to the Deason Center for your help and for hosting IDRA's monthly events. And I think that's all we had for today. So again, thank you, Jessica. Thank you everybody for being here and participating.
Thank you so much for having me. I really appreciate it. So nice to see everyone.
All right, take care everybody. Thanks.